The Department of Labour is today hosting the annual 4th CCMA Labour Conference. The conference is themed 25 years in pursuit of social justice and equity to encourage conversations affecting the labour world as a whole. The Minister of Employment and Labour, Thulas Nxesi, will deliver an address on the importance of dispute resolution institutions and effective legislation. SABC Economics reporter Katlego Legodi is at the conference and joins us now live. Katlego, very good day to you. Very important conversations this as a government and a social civic organization try to figure out the way forward just in terms of dealing with labour and that bloated salary bill in government, creating further conflicts between government and labour. What has been said so far?
Most definitely, a very good morning to you there in studio. Just to say that it's been 25 years since the formation of the Labour Relations Act, and this event here, this conference here, the Labour Conference, is set to address some of those issues where delegates here from the Labour fraternity, from the legal fraternity as well, are just gathered here to just take stock on where we are 25 years later. You can imagine that the CCMA has seen a lot of cases being referred to them, a lot of unions not happy as well with the work that has been happening at the CCMA, at the labour courts and the labour appeals courts in terms of the lengths and the times that it takes for a matter to be resolved. But the CCMA are just gathering those people, those interesting sectors here today to just try and understand where they are and just try to see if there's a need to transform the Labour Relations Act so that it's really felt on the ground. But the person that is best positioned to just let us in on where we are in terms of that act and where we are in terms of this conference, the importance of it, is the director of the CCMA, Mr. Cameron Mohajane, who joins us now live. But just let us in on that Labour Relations Act and the event here. We've seen delegates have gathered here. We've seen people from the legal sector have gathered here as well to try and create solutions and come up with solutions where the Labour Relations Act is concerned and the work of dispute resolution organs like the CCMA. Welcome to the SABC. Just how important is it, sir, that we find ourselves here? It's been 25 years. And just let us in on what we can expect as well from these 2 days.
Thank you very much for having us. We're really honored to have you here so that we can also talk to our users in South Africa. If you look at the theme of the conference, it says 25 years of pursuit of social justice and equity. The South African employment law structure has the Labour Relations Act, the Employment Equity Act, the Basic Conditions and the National Minimum Wage and other legislations. But the primary legislation is the Labour Relations Act. It will be interesting to note that since the inception of the CCMA, we have received almost 3.7 million referrals that come to the CCMA, not even counting bargaining council, not even counting the labour court. That suggests that we have a very conflictual society. But what is important is for us to achieve the objectives of each and every one of those statutes, and amongst those is labour peace. You've seen the strikes that have been happening over the years. You've seen the latest one, Nxesi. One of the objectives of the Labour Relations Act is to make sure that there's labour peace. We have intervened in all those disputes. The bargaining councils that were created has also intervened in some of these disputes in order to achieve labour peace. But in doing so, we must also achieve economic development. We must also achieve social justice. So in other words, if you have been dismissed and it's an unfair dismissal, you must be reinstated. That's what the law says. And the past 25 years, all of that has been happening. What we must do is to reflect whether we have achieved that or not. And the true test of doing that is to look at exactly the purposes of the different legislations and test if we've achieved that or not.
More or less challenges also coming from the union side to say that most of the time cases are referred to the CCMA. Most of those cases are just quick to be referred by the commissioners. Sometimes they're also complaining that there are lack of commissioners, enough commissioners on the ground to deal with these matters, and also taking issue with the labour relations or the labour appeals court to say that when a matter is referred now, it moves to the labour appeals court. There's that process where we're seeing the employer moving to take the matter on review. It takes years, just more or less disadvantaging the employee that approached the organ to really intervene in this regard. Is this something that you've also picked up? Is this something that we're reflecting on here? And could we see at least tangible, more or less reflections and tangible resolutions coming out of this that would help to allay fears from the employees and the labor unions that are out there really crying foul in terms of the works of these organs?
Absolutely. The Constitutional Court held in the UCT versus Nxesi case that the foundation of the Labour Relations Act is job security. And therefore, if we can't achieve that in terms of the remedies when we're dealing with a dispute, then we are not winning. The matter referring to on cases taking 4 to 5 years, some of them even 7 years, like the Sidumo case took about 7 years that the judge president talked about. You ask yourself a question. From the time when the award was made, that the person must be reinstated, and the matter gets challenged for the next 7 years, and it ends up at the Constitutional Court. No one asked what happened to Sidumo himself during the process. He's waiting and not understanding. But the CCMA said I must go back to work. So what is happening? You go to the Labour Court, you go to the Labour Appeal Court, you go to the Constitutional Court. Many of those cases exist like that, and that is a problem. That is offending exactly what we call the expeditious resolution of dispute, meaning that we must resolve these type of cases as quickly as possible because they hit the heart of what we call social justice. The issue of the union representation and lawyers, they do contribute, of course, as the judge president say, that sometimes you find intra-union rivalries, that you find an employee is represented by the same union but two different officials because there's an intra-union rivalry issue that is happening. Sometimes it's inter-union rivalries that are happening. As a consequence of that, it contributes into the delay of the matter, not necessarily because it is the system of the Labour Court, it is because of the representation. Also, these issues of raising very technical points that will take 7 years, like a Miyataza case, the issue on whether prescription applies to an award or not, it took about 7 years for that to be resolved. That can't be correct. That is not exactly what was intended. So we are gathered here with all the experts that you can get. The Chief Justice is coming, the Judge President of the Labour Appeal Court is here, the business, Professor Mohale will be talking as well. Professor Mpedi is talking about the issue of social security, which is a very important factor. So when you bring all those type of experts together, we are saying, and I wish that Judge Van Niekerk was also here because he wrote a very good paper about the issue of duplicating processes. You go to a disciplinary hearing, it runs for a year. It comes with the CCMA says you must start de novo, meaning afresh. Then you start redoing exactly the same thing. So is that what was the act intended? No, it's not. So we are gathered here to reflect in the past 25 years on those type of shortcomings and also celebrate the good things that we've done as the CCMA and also as the bargaining councils and also as the Labour Court. So we have to have very professional and highly intellectual contributions for us to find solution to those problems.
Mr. Mohajane, thank you very much, sir, for your time. The director of the CCMA there joining us to just let us in on what we can expect in the 2 days. This is a 2-day annual conference in its 4th installment, and we've seen those delegates really just gathering here. About 500 delegates from various sectors just gathered here to iron out and reflect in terms of where we are, where that Labour Relations Act is concerned. Also just taking a moment to reflect on the cases. You had the director of the CCMA there talking about millions of cases that have been referred to the CCMA, and it remains to be seen really if those cases have been resolved to help the employees that are in desperate need of assistance. Looking at also the socio-economic challenges that exist on the ground, where really job security is an issue on the ground, where people really are in need of jobs, and just the job that you have, the little that you have, securing it at that point in time is very, very important. And these institutions and organs like the CCMA, they are dispute resolution institutions that are poised to intervene and address those matters. But it's back to you in studio as that conference continues on the ground.
Absolutely, Katlego, they're spot on that not only job creation is important in the country, but job security